Aiden Kearney versus Catherine Peter.
No, I'll just ask him. And good afternoon again, folks. For the record, we had started a proceeding without any testimony earlier, maybe an hour or so ago, and I'm hopeful that you each have had a chance to look at your cross affidavits.
Yes, sir.
Right. So, Attorney Maloney, are you representing Mr. Kearney in both his case against Ms. Peter as well as her case against him?
All matters, sir.
All right, fine. And you've seen the affidavit and the allegation made against him. All right. So at this time, ma'am, I would ask you to testify why it is that you think this order should be issued on your behalf.
Yes, sir. So what I would offer to the court, because I don't want to presume either the court's cyber literacy or lack thereof, is the U.S. DOJ Cyber Misbehavior Attorney's Bulletin from May 2016, volume 64. It outlines some cyber stalking and cyber harassment behaviors. This is what this case centers around. They include repeated, unwanted, intrusive, and frightening communications from the perpetrator by phone, mail, and or email, making direct or indirect threats to harm the victim's children, relatives, friends, or pets.
I need to stop you there. What is it you're reading from again, just so I understand?
The Department of Justice Cyber Misbehavior Attorney's Bulletin from May of 2016.
Okay. Counsel, have you seen this document?
No, sir.
All right, and this is some sort of a regulation, or is it a regulation?
It goes after some of the federal laws understanding as far as cyber harassment and cyber stalking.
All right, but what I need you to focus on are the allegations in this case, not so much the body of regulations that might be from the U.S. Federal authorities. The question here in Massachusetts is whether or not the person who's asking for the relief, that's you in this case, and it's Mr. Kearney in his case, whether that person has been subject to harassment as the term is defined under our law.
Sure. So
it's not so much what the Attorney General may have done in the U.S. system, it's what the statute controls here in Massachusetts that governs what I have to decide.
Sure. So on February 16, 2020, Mr. Kearney did acknowledge that his actions would cause me fear. He stated, now for the first time, she's referring to me.
Are you referring to something in your affidavit, or is this something else?
This is something else.
Okay.
This is the pattern of behavior has been ongoing since the issuance of the order.
Okay.
It has become so egregious and bothersome that the local police have actually, and I do have the police report, declined to take any more of his phone calls. So he actually sent out a cyber mob after the North Attleboro police. I do have documentation of that as well. The police stated when they summarized the report, and I'm going to quote from this, excuse me. Contrary to Kearney's assertions, there is insufficient evidence of wrongdoing on the part of Peter to bring any charges. Furthermore, this department will not be compelled into misguided action by Kearney's antagonistic online posts. Should Kearney report anything additional, he will be referred to the Holden, Massachusetts Police for further investigation.
All right, so let me make sure I understand what you're referring to. Something that occurred in North Attleboro that you're saying Mr. Kearney prosecute or attempted to prosecute cases with the North Attleboro Police that involved you as a defendant?
Correct.
Okay, tell me about that.
He is asserting that and this is in his affidavit as well, it is patently untrue, that I hacked into his Facebook account to write myself a threatening message. That did not happen. I provided the North Attleboro Police with a copy of my IP addresses, all my logins, and my location history to demonstrate that I had no access to his account at the time. They took some witness testimony about an individual who had removed his Facebook accounts from admin privileges on Mr. Kearney's page within a 3-minute period. He did explain it's because he did not want to be involved in this situation. Mr. Kearney continued to harass and hassle the police, insisting that I be charged, arrested, and prosecuted. And when that didn't go his way, he went ahead and he made incendiary posts in both the blog and online, encouraging people to call the North Attleboro Police Station to have me arrested. So the result of that in the end was that the North Attleboro Police are now declining to take any more of his phone calls, and they did obviously feel that his posts were antagonistic, harassing, and were done with the intent to compel them to do something that they would not otherwise do.
Okay.
As far as the intent of his actions, he has stated on 2 different occasions and said that he acknowledges that his actions would cause me fear. He said, now for the first time, she's referring to me, and there is a tag on Twitter to this. On the other side of that, and that has to be scary, he had also sent me a text message the day that I petitioned the court for the order that included the line, I really don't fear dragging this out, but I know that you do. Mr. Kearney has...
When you say dragging this out, what do you believe that he's referring to?
He is referring to February 12th of this year when I asked to part ways from his blog. I was writing under his blog. I asked that I no longer be involved in that. He took this as some sort of feud. There were some words exchanged in the beginning that were unpleasant. And at some point I just asked that I be left alone. Please don't speak to me. Don't post about me online. Just please leave me alone. He has failed to do so.
When you say there were words that were unpleasant, what are you referring to?
I called him a scam artist. I said that, if he's not able to support himself with his blog and he needs to solicit donations, that he should get a job. They weren't nice things. They were rather pointed. I don't consider them abusive or threatening or anything like that, but they certainly were not, I wouldn't speak to my mother like that. But he then just started threatening me. He said, I asked him 3 separate occasions, and I do have the text of that, to please stop contacting me. He said things like, I'll leave you alone, tune in tonight, I guess, you could apologize, and call me and apologize, or we can do this the Turtle Boy way. He is referring to his online blog, because he does engage in the act of cyber mobbing, which has actually seeped over into almost every single facet of my everyday life. He sent me another text saying, let me know
So by that, you're saying cyber mobbing. So you're saying what he's doing is using his online presence and platform
to direct harassment my way.
To do what?
So he's painting me in an extremely negative light. He's making ominous, threatening statements publicly.
What do you mean by ominous, threatening statements?
Things like, this isn't over. Hold on, I can actually pull that up. I mean, the volume alone in which he's posted about me, even with the order in place, I find extremely concerning. These are all posts that he's made. I mean, we're talking pages in the 200s here. He doesn't.
The gist of it is what? So I need to understand what it is that you're alleging is the act of harassment.
So this is a comment that he made in reference to me. I got plenty more where that came from. I'm done playing nice. If this bitch wants to play with fire, we can burn everything. She's fighting out of her weight class. On another instance, he accused me of maliciously shutting down his online store, which upset people. It has come to my attention that a former blogger, who shall not be named, has maliciously shut down our online Printful account, which contains most of our items in our online store. Some of these items I have, but essentially, again, painting me as some sort of psychotic, bitter ex-employee. That was not the case. I provided evidence to the police. They did document that. I did have an account with his store. It was under my personal email. As of February 13th, after I separated from Mr. Carney, I shut down that account because why would you keep it open? I had no more affiliation. He also does, he's posted, we haven't even gotten to the really interesting stuff yet. He posted my court affidavit online. This is on a blog page with 20,000 people. My affidavit for the harassment order he posted online while the order was in effect. Okay. There's much more. He makes disparaging comments about my children, my husband. It gets much, much crazier, like it's very hard to hold in, but I will until March 10th, which indicates that this is his version of actually adhering to the court order, and I take that as it's going to get worse for me. Here's another one where he says it's far from over with her. Here's another one where it includes the line, when I say you'll see, that means trust me, you'll see. This is another one in reference to me. There's a psychopath hacking into our accounts, writing threats to herself, burning trucks, and trying to send me to jail. I'm sorry that you find this boring. Maybe I should milk cows again.
I'm sorry, so what are you saying? He's alleging that you're hacking into his account?
Yeah.
And posting that?
He tried to get me prosecuted for it, and the police thoroughly investigated it. I did not do that. The post in question, as the police noted as well, he claims was posted within a minute. It was deleted. They found evidence that it was up for 3 hours. It was an extremely pointed and threatening post. I understand that he contends that, but again, there is absolutely no evidence that I did that. I would not do that. I want no contact with this man. I just want him to leave me alone. That's all I want.
All right. Attorney Maloney, do you wish to inquire?
Yes, sir. Ms. Peter, good morning.
Right.
For clarity, you previously worked for Mr. Kearney, correct?
Correct.
And that was under the corporation Turtle Boy Sports Forever, LLC?
I believe it's Turtle Boy Sports.
Turtle Boy Sports,
Yep.
LLC? And that's a publicist organization that he has, correct?
I'm not sure what the actual incorporation is, no, but essentially it's an online blog.
It's an online platform?
Yep.
Okay. And now you yourself participated in that online platform. Is that accurate?
For about a year, yes, sir.
Excuse me?
For about a year, yes, sir.
Okay. And now to this day, you continue to operate in that sphere. Is that a fair statement?
That would be an unfair statement as of right now. A lot of this harassment borders on what I would consider blackmail, as he has made demands that I not operate in that sphere. So for the time being, no, I do not.
Respectfully, so are you or are you not currently engaging in an online platform for?
Currently, no.
No. Do you own the handle Masshole Report?
I do not.
You do not own that
No.
report?
No.
Are you familiar with that handle?
I am familiar with it. I'm associated with it. We do YouTube, but I'm actually not the owner of that handle. No.
Who is the owner of that handle?
Do I really have to say that in open court?
The question is it you?
His first
Does
name
it matter?
is Mitch. I don't feel.
Do you have access to that handle?
I do.
Okay. And so you don't own that handle, but you have access to
I
that
do.
handle. And what that means is you're able to post using the handle Masshole Report. Is that
I am,
correct?
yes.
With the court's permission, I'd like to hand a document to Ms. Peter.
Sure. Chief will help you with that.
Ms. Peter, can you have a look at the yellow italicized and let me know when you have a moment to read that, please?
Yes, I've read that. That is per his affidavit.
That was what I just.
I'm sorry. This online post per his affidavit was 2/12. That was before the issuance of the order. That was about 10 days before I felt it necessary to petition the court.
Okay, so for clarity, this was drafted just a few days before the order seeking the harassment prevention order, correct?
No, that was drafted over 10 days. So
10 days before.
Yeah, over 10 days.
And can you read the highlighted part, please?
I said, I'm certainly not afraid of Aiden Carney. Splitting amicably would have been my preference, but there's a reason all of his bloggers left. South Shore Turtle has agreed to explain why she left too. Quit the lying. Some of us are still invested in the truth. Be well, Aiden.
Thank you. So, prior to your seeking the harassment prevention order against Mr. Kearney, you drafted a memo online published that said, "I'm not afraid of Aiden Kearney," correct?
Circumstances changed, correct?
And the
I didn't hear
circumstances,
what you just said.
I said the circumstances changed, but correct.
and the circumstances changed
When he began sending me an inundation of threatening texts where he not only referenced myself, but anyone that I, quote, love and care about.
And what other handles do you currently own, Ms. Peter?
That's it.
Do you have any other sort of online posting or blogging?
I deactivated my Facebook.
When
I
did you do-
deactivated my Twitter.
Prior to deactivating them, had you posted any information about Mr. Kearney?
Publicly?
Yes.
No.
You didn't publish anything about him or his family?
Public? No.
Privately?
Privately, yes.
I think your client is.
Give me one second.
Your attention.
At any point did you post pictures of Mr. Kearney's children?
Privately or publicly?
Yeah.
Sorry, I didn't. You said privately. What? I just didn't-
Privately or publicly. The reason you ask, Your Honor, is because Mr. Carney has also been accessing a private Discord server that I have. I do have some information about Discord. It is a private platform. He has no business on this platform, but he continues to access it.
Counsel's entitled to ask the question, but just so that I understand, I would ask that you couch it in terms of whether this is intended to be a private or a public platform. The difference may be important for this operation, but it may not be for this case. I have no idea what lies ahead, but
Understood,
if you
sir.
would, just so that I understand whether she's responding to your question about a platform that's publicly viewable versus only privately viewable, at least let me know.
Understood, sir. Ms. Peter, I'm going to pass that picture to the court officer. Could you please identify the picture and please specify where you posted that picture?
Yep, so this is a picture of Eden Carney, his son, with a Disney character during his Disney vacation that he posted to his Facebook account. It was posted privately to a private Discord server. And to elaborate on that, what that was to retort a claim that he had made publicly about me that nobody knew that he had gone to Disney. This was to prove that he did actually post pictures of his Disney trip on his Facebook.
Ms. Kearney, without belaboring the issue, so is it fair to say that you published some photos of Mr. Kearney and his family when you were disgruntled or concerned with the way that you were being treated online?
Disgruntled, no. To refute a claim, yes.
Do you own the handle, I'm going to, Aitch Paul, A-I-T-C-H Paul?
I do not.
Did you own the handle?
I did not.
Did you ever have access to the handle?
I had access to it in August of 2019 when I was under Facebook suspension.
And you had access to it when?
August of 2019.
That was the last time you had access to it?
That was the last time I had access to it.
Ms. Peter, you previously worked for Mr. Kearney, correct?
I answered that, yes.
And that relationship has since terminated?
Correct.
And that, after the termination, that is when you filed a harassment prevention order against him, and he filed one against you?
No, after that event, yes, directly after, no. I filed one after I received a barrage of threatening texts, and there were a barrage of threatening Facebook posts made about me, yeah.
What was the reason for your termination?
Termination, I left because I was uncomfortable with some of the ways that he operated. It was a personal decision that I made.
Okay. And just give me 1 second here. At any point, did you receive, I don't want to go too far off the rabbit hole, but just give the court a little bit more context here.
Well, if you're done questioning this witness, that's fine. You want to make an argument, you can. But if you have any further questions, you can ask.
I'll keep it very brief. At some point prior to your severing term employment with Turtle Boy, did you receive compensation via Venmo for a clientele that was intended to be directed towards Mr. Kearney?
That was intended to, no.
Did you receive compensation via Venmo that was intended to go to the Turtle Boy Sports Corporation?
No, I did not.
I'm going to show the court officer one more picture. Could you please take a look at the highlighted yellow? Let me know when you do.
Yeah, I said, just in general, I absolutely should have consulted you about Chris, but it was fucking careless, not malicious. That Venmo that I received per the business owner and myself was not intended to go directly through Mr. Kearney. If you're referencing that, Mr. Kearney and I had an agreement that I would collect payment for my work and then we would settle up at the end of every month. I absolutely, as a human being and somebody who I consider to have a working relationship with Mr. Kearney, express my regret that I did not better communicate that with him, but to frame it as some sort of theft is ludicrous, and the business owner has refuted that publicly many times as well.
Ms. Peters, is it fair to say that all the communication between the two of you since you are no longer working with Turtle Boy has been electronic?
I
mean, yeah, we haven't had much communication other than what he's tried to send my way.
No further questions. Thank you.
Okay. Do you wish your client to testify?
No, sir, I do not.
All right. So if you have anything in response you'd like to say, you have an opportunity to...
I do actually, so I haven't even... As a result of these ongoing posts, and again, the volume alone I find to be extremely concerning, particularly where there was a court order in place, I have had my job threatened by individuals that are associated with Mr. Kearney.
Well, wait a minute. So you have to understand something. There's one plaintiff in front of me and one defendant. There are two cases, it just complicates it, but there's only one plaintiff, one defendant.
Correct.
So when you're alleging that there are other people who are allegedly committing some sort of acts, that's not germane to the question here, unless you're saying that there's some sort of, that the pattern of harassment is through him.
As I would say, so right here I do have some comments from an individual. He clearly cites the reason is the only cause I see here is fighting for Turtle Boy. That's Mr. Kearney's blog. I'm not going to sit back and watch this drunk psycho even attempt to destroy something I enjoy.
But I don't know who that's from. So
this is an individual by the name of...
No, but it's not from Mr. Kearney. It's another individual that you're referring to this document?
Correct.
Has authored something referencing his intent?
Well, this particular individual has referenced my job over a dozen times. They're all contained within this Writers 2.0 group. It is a private group of Mr. Kearney's related to his blog. He clearly...
I'm trying to get a sense of who the author of that is. Some other person.
Some other person, correct.
Right, so it's not germane to this hearing.
I've also received numerous anonymous emails and phone calls to my job demanding that I be fired. Several of them do reference Turtle Boy Sports or Aiden Kearney by name.
Several of them reference. So are you suggesting that Mr. Kearney sent them?
I couldn't tell you who sent them. That's one of the big pitfalls of the anonymity of the internet. However, I have never had these issues with my employment prior to this conduct, and he is referenced. We also had an incident where there was a truck fire intentionally lit on my property. Again, could I allege that Mr. Kearney did this directly? No, but we have never had these incidents prior to this conduct, and this fire was set within 4 days of receiving the order. He's written 5 separate blog posts since the order was issued that are incendiary towards me. He accuses me of committing crimes, interfering with his business. I've had no contact with this man. As a result of this, it does incite people to act. He's also involved with a page by the name of Not Turtle Boy Sports that was designed just to target me. Again, I'm borrowing from the language in Mr. Kearney's own affidavit when I say target. The page he absolutely is connected to. Right here we have a statement from a Randy Lucia that says, Aiden told us to name that page that. He also has a documented connection to the page through the profile that he uses, Terrence Colley.
Are there any further questions?
No, sir. I realize this is not a normal judicial proceeding, but I feel I would be objecting otherwise. I mean, this is reiterating hearsay repeatedly in regards to online platforms, some of which Mr. Kearney may or may not be involved with. The fact that an alleged arson situation is even brought up here, I think, is totally inappropriate. Judge, I would respectfully suggest to the court that, like the previous HPO and 209A that you heard, this is essentially a case of a disgruntled employee-employer relationship that went south. Ms. Peters was working for Mr. Kearney for the better part of a year and a half and participated extensively in online performances that were done to elicit a strong public support. He has had a following for a very long time, continues to publish to this day. Ms. Peters, having worked for Mr. Kearney for the better part, like I said, of 18 months, essentially used that as a spin-off to continue to promote her own platform. Judge, I would suggest this is employee-employer and grossly outside the parameters of which these HPO and the 209A are intended for. I would suggest that neither the petitioner in this case or the petitionee in this case, neither of these requests to solicit an order fall within the purview of what the order itself is intended for. And I would suggest that both fall on their face and should not be extended.
All right, so are you asking for your client to testify in his case in chief?
No, sir.
Your argument that if I just heard your argument correctly, you're suggesting not only should Ms. Peters' claim fail, but your client's claim should fail.
That's exactly what I'm suggesting, sir. With no disrespect and not taking away any credence from Mr. Kearney. He's not informed in the law. I spoke with him in the hallway. He's looking to move on with his life. And it was filed in part as a defensive mechanism when he was attacked online.
All right, folks, it's extremely troubling to hear the nature of what the court has before it this afternoon. In looking at the allegations that are made both in Mr. Kearney's affidavit as well as Ms. Peters, it's very clear that there's something very wrong here, right? We have people alleging really serious, ugly stuff, right? But the issue before this court is not whether there's some sort of online presence that is hell-bent on destroying each other. That's not really the issue. The issue before the court is whether the person who's looking for an harassment prevention order is subject to harassment as the law defines it for purposes of this statute. Let me just explain. I have before me a 2014 case. I'll cite it for anyone who wants to look it up. Kenneth Sene versus Don Maury, 467 Mass 58, a 2014 case. It is an appeals court case. And in that case, loosely, I will sort of identify that the plaintiff in this case was a Little League baseball coach. The subject of the case basically is the harassment order against the defendant in this case. The district court judge held hearings over the course of 2 days, during which the head and assistant coaches of the baseball team testified about the defendant's actions. The plaintiff testified to 3 incidents in which he claimed he'd been harassed by the defendant. First, plaintiff learned that in a telephone conversation with the head coach of the team, the defendant threatened to, quote, punch the plaintiff in the face and break both of his knees if he acted in a certain way towards the child, right? Remarks that caused the plaintiff to fear that the defendant would physically injure him. Second, the plaintiff stated that electronic mail messages that would basically disparage. I'll just loosely paraphrase, but it's disparaging because people in this particular community were active online, and this sort of public bashing was taking place, which is an awful thing, and it becomes more and more prevalent. But that's not what's before. That's not the basis for an issuance of an order. I'll state also that in that case there was a third allegation that the defendant threatened to harm him, that he feared that this plaintiff, the defendant, would not stop berating him in front of all other parents. During that third incident, he attempted to defend his name. Plaintiff wrote that he was fearful for him and his family that was implicated in this situation. The judge in that case issued an harassment prevention order, and the appeals court reversed, saying it is not the basis of an harassment prevention order. And unfortunately, we find ourselves more and more with, especially this online presence, it carries a huge imprint, but yet it's not subject to harassment prevention order because what's missing is the criteria that's set forth under the statute, which is 3 or more acts aimed at a specific person, willful, malicious, done with the intent to cause fear, intimidation, abuse, or property damage, and abuse is defined as I've stated it. The appeals court was very clear in that case involving the baseball coach. Now, could it give rise to civil remedies? Absolutely. And those people who put this stuff out, I suppose, do so at their peril. What's alleged before this court is that somebody is doing illegal activities for purposes of their game. That's what's alleged, right? On both sides. And the only agreement I would have as Attorney Maloney with you is that that sort of public discourse is for another forum. It is not the basis of an harassment prevention order. I hope I've defined that for you so that you understand that and what the ramifications are for what this case that I cited, the words they're using are true threats. That's what has to be found. There are other cases with people flipping other people off, some really nefarious actions that were not held to be sufficient under the harassment prevention order. Now, could that change? Absolutely. Could change in a heartbeat if somebody were to engage in the type of activity proscribed by this particular statute. Ma'am, it looks like you want to get my attention.
I'm sorry. Sorry. With all due respect, I would like to just again reiterate and point to Mr. Kearney's communications with me, where he did explicitly communicate that he was intending to put me in fear.
Right. And so, ma'am, I would, not that I have to make specific findings under the situation, basically that we're being recorded, everything is available for appellate review. But in the testimony that's before the court, I'll just recap a couple of things. There is an awful lot of, we'll call it public trash talk, right, that you've presented. It's really awful stuff. And you're mentioning family members, and you're mentioning that this is serious. And I take you at your word that that is serious. There's also credible evidence that in retaliation to that, you've submitted responsive comments which were designed to sort of poke the nose of this. Well, it is in evidence, ma'am, and I know that you're shaking your head and maybe you're disagreeing with me. But that language is in there, and that's your words yourselves. May not have been retaliation, but it's to that end, that there's this sort of going back and forth. At some point, our society, I suppose, will put statutes in place to prevent this type of behavior, because as a civilized society, we have to ask ourselves, do we want to be subject? Do we want to have our children's lives and the lives of people we care about treated in such a fashion that you both are presenting to this court today? On both sides. I'll mention it's alleged on both sides. The answer, I would hope, is no, we don't want to put up with this. But to the extent that it's out there, it is not part of this case. Ma'am, the last point on this, I'll give you an opportunity.
I would point to the matter of Zoe Quinn that was out of Massachusetts. It is colloquially known as Gamergate. An order was granted to Ms. Quinn, even though the defendant in that case had not explicitly threatened her. He used a similar modus operandi as far as the blogs, dissemination of personal information and threatening communication. So I have seen that it, this does apply.
Oh, don't make no mistake about it. I'm not saying that someone who says something by way of by electronic communication is immune from liability. Think about the texting suicide case. It was internationally reported. It occurred right in this area, right?
Plainville.
Yeah, and so that is an example. The criminal conduct that was found by the court and ultimately upheld was the same as if the person was standing right next to them. The criminality was that person had committed the crime of basically encouraging another person who had started to commit suicide to abandon it, and then who abandoned it to then get back in. It's no different than if you were standing next to that person next to a bridge, and the person was going to jump off, abandon it, and then you encourage the person to go back over. So words have consequence, folks. I'm not saying that at all. And I understand what you're saying with the Zoe Quinn case. And we have a whole lot of domestic violence statutes that are designed to stop that. We have stalking statutes where we never did before. We have an harassment prevention statute where we never did before. So all I'm saying is under the circumstances of this case, in the confines of what has been alleged by both sides, it does not meet the criteria. Good luck, folks.
Thank you, sir.